Thank you very much, everybody, and good evening. So I think class actions are a good jump-off point for the presentations today. Because of the incentive structure inherent to class actions, it's one of the central places where legal issues raised by our increasingly global world manifest themselves. So today I'm going to go over 3 cases that touch on 3 different lessons that all of us need to be aware of as we navigate the waters of international commerce. Each case points to potential uncertainties, but also suggests ways that you can be prepared to deal with these issues. So the first lesson is your class is bigger than you think. And I'm going to be talking about the Area Brands case. So the last 5 years in particular have witnessed a proliferation in the number of cross-border class actions, particularly in the securities and competition context. It's becoming increasingly more common for Canadian plaintiffs' counsel to pursue class actions in parallel with those in the United States. The data is up there. We're looking at almost 50% of class actions as of 2016 that are essentially copycat claims of those started in the States. Now, as part of this trend, Canadian plaintiffs are more frequently advancing claims on behalf of global classes. And this includes claimants that are not resident in Canada and have little or no connection to Canada. Now, whereas previously Canadian courts were reluctant to exercise jurisdiction over foreign class members, recent decisions from the Court of Appeal mark a shift in this jurisprudence. And I'm going to be focusing on the Area Brands decision. So what is this case about? In Area Brands, the plaintiffs allege that a group of global airline carriers conspired to fix prices of air freight shipping services. The proposed class included residents of at least 30 countries. Many class members resided outside of Canada, suffered losses outside of Canada, and had little or no connection to Canada. The defendants brought a motion for a declaration that an Ontario court could not exercise jurisdiction over the foreign claimants. Now, at first instance, the motion judge agreed and excluded the foreign claimants from the class definition. That brings us to the Court of Appeal, which overturned this decision. It held that jurisdiction over foreign claimants could be established where the following 3-part test was made out. Number 1, there is a real and substantial connection between the subject matter of the action in Ontario. 2, there are common issues between the claims of the rep plaintiff and the foreign claimants. And then number 3, the procedural safeguards of adequacy of representation, notice, and the right to opt out of the class are provided. Essentially, the court wanted to make sure that the foreign claimants are getting a degree of procedural protections. What does this mean? So I think we can take 3 points away from this case. 1, you can expect to see what I'm calling a rise of zombie class actions. Why zombie class actions? Part of the decision in Area Brands was that jurisdiction could be exercised over foreign claimants even where there was a doubt as to whether or not the judgment of an Ontario court could be enforced in the foreign jurisdiction. So from a defendant's perspective, you have all of the negatives of a global class, i.e. high damages amount, with none of the benefit, i.e. the preclusive effect of an order. Add that to the reality that a lot of these foreign claimants probably aren't even going to have any idea that the class action is even going on, and you get something that is called a class action, but it doesn't resemble what you would typically think of as a class action. Number 2, the case removes a weapon from the arsenal of defense counsel, and now when you see a U.S. or a global class action, you need to assume that it's coming to Canada, and you need to recalibrate appropriately. And number 3, it'll be important to coordinate defense counsel strategy. You're going to need to see a degree of coordination in terms of the arguments put forward by Canadian counsel and U.S. counsel. Just one example, if U.S. counsel in a copycat litigation is arguing that the U.S. court has no jurisdiction, a Canadian court might take that into consideration in deciding whether or not to certify a global class. One of the concerns might be that, well, if we don't certify this, these poor foreign claimants aren't going to have any avenue. And that's precisely what happened in the Silver and IMAX case. So, lesson number 2, you can't close yourself off from the world. And we're going to be talking about the Facebook case, which is really about form selection clauses. And this follows from the Area Brands case and some of the issues discussed there. If you know that you potentially face liability from around the world, you're going to want to construct some sort of wall to keep the world out and to protect yourself. And that is why corporations seek, and that's what corporations seek to do with form selection clauses. As the Supreme Court pointed out in the Facebook case, companies use these clauses to prevent themselves from being dragged into foreign litigation. However, the Facebook case suggests that the wall might not be as impenetrable as we once thought. So what's this case about? It's a proposed, or it was a proposed BC class action based on statutory claim for misappropriation of personality. Essentially, Facebook had a product where if you liked a company, an ad would be generated that said, oh, Carlo DeCarlo likes company X. Now, the key point is before joining Facebook, all users agree to terms that essentially say that all disputes will be determined and settled in California. Facebook brought a preliminary motion to stay the class action on the strength of the foreign selection clause. Now, there's a two-part test when dealing with one of these clauses. First is just, is the clause enforceable, and that's just a contractual issue. The second, and this is where a lot of the litigation is determined, is there a strong reason or strong cause not to apply the clause? Now, the motion judge found that there was such strong cause and allowed the class proceeding to proceed. That was overturned on appeal. So what did the SCC say? Well, that's a good question. It was a 4-3 decision, and the majority refused to enforce the form selection clause, meaning the class could proceed. But there were 3 sets of reasons. 3 found strong cause, 3 did not. 1 decided unhelpfully on contractual principles. So the precedential value of the case is unclear, but it does send a signal, and it's worthwhile looking at the 3 who found strong cause. They found in particular that a modification of this factor is required in the consumer context to reflect public policy concerns. Here, 2 public policies were at play. The clause was in a contract of adhesion between an individual consumer and a large corporation, and there was a large imbalance of power. Number 2, Canadian courts have a greater interest in adjudicating cases involving quasi-constitutional rights such as privacy rights. So what does the case mean? Well, you shouldn't assume that a foreign selection clause will protect you. There's going to be uncertainty, especially when there is an imbalance, especially where constitutional or quasi-constitutional issues are at stake. The Uber case provides a potential counterpoint. This was an employment class action with an arbitration clause that said all disputes would be determined in the Netherlands. Now, there, the court found that this provision was valid, and part of the reason why was, well, this isn't a forum selection clause, this is an arbitration clause, and that's completely different. It's not sure, or it's not clear whether that reasoning is going to hold up, but for now, that might provide a potential way of getting around the Facebook problem. I guess we're going to have to wait and see. That moves us to the last lesson, and that's getting by with a little bit of help from your friend. And for this, I'm going to be talking about the Manson case. So Manson deals with a recent emerging trend in multinational class proceedings. It's the attempt to use evidence that's being compelled in one jurisdiction in a class that's being argued in another jurisdiction. And as I noted at the outset, this is going to be relevant in Canada because of the large number of copycat claims. There's a particular tool in the States, that is Section 1782 of Title 28 of the U.S. Code. Now, this is a pretty broad provision. Essentially, it allows any interested person, that is, you don't even need to be a party, to go to court and apply on an ex parte basis for an order compelling testimony of somebody. So in Manson, which was a foreign exchange price fixing class action, where the allegations were that financial institutions conspired together on Bloomberg. The class went pre-certification to the states and obtained one of these 1782 orders. They did this ex parte without any notice, and this is a key point. At the 1782 application, the only evidence was a declaration from one of the plaintiff's Ontario lawyers. And in this declaration, the lawyer stated that he was not aware of any rule or policy that would preclude the plaintiff from submitting this evidence in the Ontario action. Now, the Ontario court later on found that this declaration was misleading, and we're going to get to the importance of that finding later on. Going back to the states, though, the U.S. court granted the order, subpoena was issued, and Bloomberg was served the next day. Defense counsel predictively voiced opposition and brought a motion to bar the plaintiffs from using this evidence. So at the end of the day, the court granted the motion and barred the plaintiff from using this evidence. Now, there's 4 reasons why. I'm only going to focus on 2. The first reason was that the plaintiff was not just gathering evidence. So the court goes into the jurisprudence and finds that there's a dichotomy between Canadians who are just going to the States and using 1782 to get evidence that has already been discovered in the U.S. proceeding, as opposed to Canadians going down there and actively creating evidence. The latter is going to be problematic. The former might be acceptable. And then I'm going to jump down to number 3. Plaintiff's conduct was undermining the jurisprudence about class action procedure. The court very jealously protected the rule in class proceedings that there should be no evidence and no discovery pre-certification. They found here that class counsel was offside of that rule, and that was one of the reasons why they barred this evidence. So what does this mean? There are 4 quick lessons. The general point is this case doesn't stand for the principle that you're not able to use 1782. What it does, though, is it sets ground rules. It makes clear that, number 1, if a plaintiff does this, defendants have access to Ontario courts to try to bar the evidence. Number 2, timing matters. If this is pre-certification, you have a pretty strong argument to bar the plaintiffs from using this evidence. Number 3, who are you getting the evidence from? If you're simply going there to get discovery that's already out there that exists, you're going to have a better chance of getting that in, as opposed to actively compelling evidence. And then number 4, it's not clear what effect this decision will have on attempts outside of the class action regime to access a Rule 17 or a Section 1782 order. So that's our trip around the world. Thank you very much, and I'm going to pass it off to our next speaker.